Well, hello there, and welcome back to another episode of Help My Business is Growing, a podcast where we explore how to grow and build a business that is healthy and sustainable. I'm your host, Kathy Svatina, a fractional CFO and a founder of Newcastle Finance, a company where we believe that everything that you do in your business will eventually end up in your finances. And to get to healthy finances is to have a healthy business. How do you get there? Well, this is where this podcast comes in to help. And today we are going to be talking about HR investigations because they are crucial that you know about them if you have a small business, because they often fly under the radar. And it can get stressful when you have to deal with employee complaints, wrongful termination claims, bullying accusations, and more of this HR stuff that you might not have to been dealing with before, and now you just have no idea how to respond. Because these investigations and accusations matter because they can make or break your business. When done right, they'll protect you and your employees, but when you mishandle them, they can lead to legal issues, you can damage your reputations, and it can cost your business a lot of money. So, how do you manage employee complaints and these accusations? And how do you conduct a fair investigation? More importantly, how does that really look like? And when should you seek legal counsel? Who should you call for help if you have no idea what to do? And what's the secret to resolving them fairly and professionally? As a quick reminder, all of the episodes on this podcast, including this one, come with timestamps for topics that we discuss, and each one has its own blog post as well. So I encourage you to go take a look at it and scan through so you can see what exactly we're talking about in this episode. You can find all the links and the detailed topics on this episode show notes. My guest today is going to be Jill Avey. She is the founder and owner of Southwestern HR Consulting, and Jill has more than 25 years of business expertise in human resources. Collectively, she and her team bring 200 plus years of HR experience to the care and support of their clients throughout the New Mexico, in 24 states, and in 4 countries, building extraordinary employers to create extraordinary work environments. Join us. Jill, you're so welcome to come to this podcast. And thank you so much for being here, because we're going to be talking about something that is really important. And I don't see people talk about it a lot in the small business community, and that's HR investigations. And you are an expert in this.
Thank you, Kathy. Yes, it's a privilege to get to talk to you about this particular topic. It is a scary topic, I think, for employers to experience some type of a claim or a charge inside or outside of their business, and how to know what to do next. Where do you turn? How do you respond? It's a critical piece that, if done well, can save employers a lot of money.
So let's talk about what is an HR investigation to begin with, and then we're going to talk about like how does the process really look like. But for someone who's not familiar with that, especially if they're in a small business space, they've never really talked about it. This is something that is pretty common in the big businesses, but what is actually an HR investigation?
Okay. So what prompts an HR investigation is an employee coming forward with a concern or a complaint about a condition of their work that encompasses discrimination. And discrimination is a really large envelope. And so, or umbrella, better said. And with that being said, it can be something in discrimination, perhaps a wrongful hire. I didn't get picked for an internal promotion because of a protected class, or whatever their reasoning might be. Remember, it's a person's perception. So we're not dealing necessarily in fact, but rather in perception. Mm-hmm. And so that's where discrimination could fall. But also what is discrimination is harassment, sexual harassment, bullying, hostile work environment, retaliation. Retaliation is probably the single most common claim that's made. And that is an employee saying, my employer has done this to me because of, And it might be because I made a claim, because I made a workers' comp claim, because whatever it is they put in that sentence to finish it. And so when someone comes to the employer inside, that is really a gift for you to understand, wow, we want to get this right for you. Thank you for coming forward. And then an investigation could pursue to understand what has transpired and what might need to change to prevent that from happening. Is there corrective action that's necessary based on what action was alleged? If an employee goes outside the organization, which they have a right to, oftentimes they'll go out because they came in and you did nothing about it. So they go out. However, they don't have to go through that step. They can go outside. And when I'm saying outside, that would be to federal or state agencies to say, hey, this is happening to me in my workplace. And then it's up to the employer to prove that it didn't. And the situation may be where they go to the Equal Employment Opportunity Commission, talked about as the EEOC. That's a federal agency, but within your state, it might be something phrased as the Department of Workforce Solutions or the Colorado Human Rights Bureau. One of those type state agencies that have responsibility around discrimination.
And is that the same as the Department of Labor, or is that Department of Labor, it's like the umbrella of all of these? How does that work?
So the Department of Labor is another department, and it is the governing department of employment. So things that fall under the Department of Labor would be the Fair Labor Standards Act, which governs how people are paid and classified, all that kind of thing. It could also incorporate practices of employers, but the EEOC is a separate agency. Okay. And the Department of Labor also has wage and hour in it, multiple departments that are involved in the employment process.
So you talked about, that the employee has options. They can either come to you as an employer or they can go outside. But what happens if you ignore it? Let's say that someone is bringing forward a concern and for some reason you ignored it, not intentionally, but maybe you just don't have the expertise in-house, or maybe it slipped, or maybe you didn't deem it to be, such a big deal, or whatever it could be. What happens if you ignore it and the employee takes it outside? Are there any penalties for you? Any financial ramifications? How does that work?
A common answer in HR with the question and answer scenario is it depends.
Okay.
So I would not be able to put a fixed firm dollar of what it could cost an employer, but it will make it more difficult for the employer to position themselves in a response to what the employee is saying. So in some cases, what the employee is saying truly has happened. And it may be that as an employer, you were aware of that and you've taken measures. So that's something that you would share in your response. But it may be that the employee has a perception of something that they feel has happened to them, and yet all the facts aren't quite as they actually played out, right? Because sometimes we take things internally and we adjust them to our narrative. And so it might not be 100% factual, and that doesn't mean intentionally, although it can be. We train employees to understand that making a claim against your organization or a supervisor that you're not happy with, that's not an activity to get back at someone. It's a very expensive, serious type of activity, and you want to be sure that you are being forthright and accurate in what you're sharing. So the organization can fix what's going on so it doesn't happen to someone else. but also to prevent a false claim that would not only harm the target who you're accusing, but it crushes your credibility to make a false claim as well. And it could result in disciplinary action, depending on what the company has in place, policy-wise.
And Jill, you also work with a lot of small businesses. What are some of the most common complaints that their employees bring forward to them? Is there like a common thread that you keep seeing?
There are a few common threads. One would be a claim that's made outside the organization based on a wrongful termination. And many times when an employee is terminated and claims a wrongful termination, what's absent in that termination is documentation, the reason that they were fired. Some attorneys will say, if you're in an at-will state, simply say that this is an at-will separation. At any time, the employer or the employee could earn or break the employment relationship. Then other employers will say other attorneys will say to give the reason so there's something tangible for them to understand. Well, it kind of depends on the situation. But if there's you're fired because someone showed up halfway through a shift, and that's the end of the documentation, the employer is not going to be situated well to combat a charge of wrongful termination, because the employee pretty much gets to say what they want. The hope is, of course, that it's factual, but it isn't always. So it's up to the employer to prove that's wrong. Without documentation, that says, well, actually, in our termination letter, we identified the issue at hand and the dates in which it occurred. And that was the reasoning for the employment or the separation. We practice EEO work environment in our organization. They can provide that from their handbook. Or if they're not large enough to have a handbook, they may have just a few standing policies. But even with one employee, we wouldn't want an employer to be without any form of policy, because they need to be protected, and they also need to be clear to the employee the expectations that are presented for their work situation. So I would say wrongful termination for someone who has left the organization. Inside the organization, what we're seeing the most is two. One, sexual harassment, and two, then I'm going to say hostile work environment / bullying. Those two particular charges are not necessarily illegal unless they rise to the level of harassment, but they're not a work environment friendly situation either. So none should be tolerated, but it's understanding what's transpired. Sometimes the hostile work environment perception is because someone holds employees to their deadline, and that feels hostile, right? That's accountability. Or someone receives a poor evaluation. Again, that's accountability. Although in evaluation, there should never be surprises, because you've been talking about all the great things and the challenges along the way. The other piece would be that, sometimes people's management styles are not necessarily friendly. It's not illegal to be a jerk. But again, it's the work culture that you're trying to cultivate. So perhaps a manager that is a bit rough on the edges, kind of minus the please and thank you, or the appreciation, or what jobs they're assigning, those kinds of things, maybe the manager could utilize some training, and that might be an outcome of an investigation. But it's a slippery slope. And so we train employees to be sure they understand what those words mean, because when it happens in the workplace, it's super important that it gets taken care of. And when it's claimed over and over and over again, and it's really more accountability, or perhaps you don't have to be besties, right? But you have to be respectful. And so you don't necessarily want to have dinner with your manager, but at the same time, you have to be respectful and vice versa. And so it's really fine tuning what those mean. And then the sexual harassment, sometimes it's just the pervasive asking out over and over and over again, or it might be something that crosses the line even further. And it could cross the line into criminal law as well, if it were a really egregious situation.
So you mentioned the employee handbook and policy, especially in terms of, I would assume that that's where you really put in what is your, that you're an at-will employer, that you can essentially terminate the employment at any time for any reason. And then also the sexual harassment training, I think that would probably be in there as well. And if you are a small business that is just starting to, start to have your own full-time, part-time employees, you're between like 5 and a couple of tens of them. When is it that you should start focusing on putting this handbook together to, avoid all these types of situations as much as possible? Would you say that the time is when you have your first employee? Is that when you should start putting the handbook together? What is your general recommendation on that?
That's a great question. And it depends. It
As
depends
it usually does.
That you're in and what some of your state requirements are. Because we have our federal requirements, but then every state gets in the chili that because they want to ensure that certain things are being handled a certain way. So if you're starting up in the state of California, I would start immediately. I would say that's true also in Colorado, Illinois, Ohio, maybe a few others. What I would say is all the federal laws don't apply to every single employer. It depends on the number of employees that you have. And what's interesting about discrimination and harassment is that it is not a requirement to have a policy and practices and procedures until you have 15 employees. Now, with that being said, we work with a lot of employers that have less than 15, that even have less than 10 or 5. And what legal counsel has shared with us is you don't want to be an employer that shows up to court in a harassment claim, pick it, harassment, sexual harassment, retaliation, without a policy, without practices, without training. Some states require training, California for one, but some states don't. New Mexico doesn't require you to do anti-harassment, anti-discrimination training, or what the EEOC really likes, civility and respect in the workplace. It's not a requirement, but you don't want to be caught without it. And so having a policy that follows the EEOC guidelines within what needs to be included, and then what your processes are. And a handbook often doesn't contain processes or procedures. The handbook doesn't have to explain all the steps of an investigation, but that an investigation would be conducted in the event that there was something brought forward that necessitated that. Now, sometimes it's simply just looking into a situation, right? It's not doing a full-blown investigation where you have interview questions and a list of people and all of that. And that kind of thing can happen internally if you have the staff to do it. There's also a lot of power for the organization to outsource that investigation. So no one has skin in the game, right? It's a objective type of investigation rather than subjective. Because if you do it internally and the employees feel like there was favoritism or that the investigator was not completely objective, then that might cause them to move outside and make the claim again. And they can.
So we talked about having employees in the business. But what if you're a business that significantly relies on contractors and 1099ers? Is this something that you still need to be aware of and have your policies and HR procedures and handbook together, even though you don't really have full-time, part-time employees, but you have the contractors? Is that still important to do that as well?
That is a fantastic question. And no. So when you have independent contractors and no employees, you don't want to engage in employment activity. So the Department of Labor governs this particular piece, and they want to ensure that your 1099 is a justified 1099 or independent contractor. And that justification there's a 20-point test. And you don't have to hit all 20 points. But some of the points that you need to make sure you hit is that you do not control that contractor. You have a contract, not an offer letter. You have a scope of work, not a job description. Independent contractors do not sign a handbook acknowledgement statement. Now, you may have in your contract that there is an expectation that there is an alignment with your vision, mission, values, whatever that might be, and that they would operate under the EEO policy of the organization where it's non-discriminatory, not anti-harassment type situation. That can be in their agreement, but they're not going to sign your policy because that is an employment activity. So you want to make sure you do a very good job at keeping things straight. And so when you have an independent contractor in your email communication, you're not assigning them. We have a new client. This is your assignment. Rather, we have a new client looking for this. Do you have capacity or interest in supporting? See the difference, the control lies then with the independent contractor. And so you want to be super consistent everywhere you can in keeping things separate.
Yep. But what happens, for example, if you have a 1099 or a contractor and they feel like they're being harassed? For example, let's say they're being sexually harassed. How does that work? Are they still able to bring in the investigation forward? Or do they go to, instead of to you, do they then go to the external party, to those labor departments that we talked about? How does that work?
Okay, another great question. So the behavior is not acceptable for anyone by anyone, right? Even if it's your clients that are harassing or sexually harassing or bullying your employees or your 1099. How you handle it, though, is different. Employment has a process. For the 1099, the hope would be that they would come forward to you so that it's something that you could address in an effort to not only protect them, but also to assist with the individual who's engaging in the poor behavior, if indeed that's happening. But it is not an employment situation. So the actions that an employer can take with an employee is much different than what could be taken with the independent contractor.
And what are some of the actions that you can take with an employee, but you can't take them with an independent contractor? What are those differences?
What are the differences?
Mm-hmm.
Is that what you said? Okay. So for an employee, the employee that is, we use the word target, the employee who has allegedly engaged in the behavior that's being claimed. If that is found to be true, then depending on the level of the behavior, the egregiousness of the behavior, the employer can do a number of things. Likely their policy would say, and we hope that they have one, because then that dictates and governs their behavior. So it's not something personal, right? It's not because this person is over 40 or because this person has any form of protected class. Rather, it's because the policy says we do this. That's the intention of the policy. And so the policy would likely say something that when findings are made in the determination of a claim, the organization may take disciplinary action up to and including termination, right? It doesn't mean they have to terminate unless they say we have a zero tolerance. If anything happens in the most significant or insignificant kind of capacity, it is termination. That is another approach. In which case, if somebody is found to have committed any form of discrimination or harassment, retaliation, then they're automatically fired. In the first example, they might be put through training. They might receive a write-up. It could be a write-up. It could be a first and final write-up. If this ever happens again, you're terminated, no questions asked. It just depends on what it was that was happening. For instance, let's say somebody has some kind of explicit sexual screensaver, right? That's sexual harassment. For anyone that sees it, that's uncomfortable. So would that rise to the level of termination? It would in a zero tolerance arena. And I'm not saying one is better than the other. It just depends on your culture and what you want to bring forward. In the first example, where the policy might say will result in disciplinary or may result in disciplinary action up to and including termination, then that person may go through some sexual harassment training. They may go through some sensitivity training, may receive a write-up, and with an understanding that it's not okay, right? And so this can't happen again in any nature. And it doesn't have to be exactly the same. It doesn't have to be within the same category of discrimination. If there is another claim.
And for the contractor, you really can, what I'm hearing is you have more options for the employee, but for the contractor, it's really about, it probably ends up, I would assume, and you tell me if that's true, it probably ends up in the termination of the contract with that particular contractor, or no.
I would suggest that if the contractor is the target, so they're the person conducting the behavior, that's a very strong probability that it could result in their termination. And there's no, what do I want to say? There's no requirements in how you do that. You can sever that agreement at any time. The contract likely says that for both parties, that, it's not not an at-will agreement because it's not employment. But the agreement can be severed at any time. There's some kind of statement in the contract, I would suspect. Now, if the contractor is the victim, then it's up to the contractor. The contractor may terminate the situation based on how the employer handled it. If the employer handled the situation to their satisfaction, then the relationship may continue. But it's really important for employees to understand that when you bring something forward that does ultimately result in an investigation, the employee will likely not know the details of the investigation. A report is usually generated, and it may be a paragraph because the supervisor looked into the situation, talked to the parties, there was a resolution, and they'll create a summary. That's how simple the investigation could be for the right scenario. However, if it's more involved and it's a formal investigation, whether it's done by HR internal or an outsourced investigator, the only people that are going to get that report should be the employer. And when I say the employer, I mean the top dog. So it would be the owner, the president, the CEO, whoever that is, or perhaps HR depending on how things were handled. But it's not something that's shared with the claimant or the target party. It's just shared that we appreciate what you've brought forward. We did an investigation and we are taking measures to ensure that we have a safe working environment. And then they may see some things, right? The organization goes through training, or they see that the person's no longer working there because it resulted in their termination. But we're generally, the employer won't talk about another employee's work situation or corrective action.
So let's talk about the process of this investigation. We've talked about, what are some of the consequences. We talked about why would someone bring that forward to have the investigation. But let's say, I always like to be very specific with, with this podcast. Let's say that you had an employee that has accused you of wrongfully terminating them, and they bring this forward to you. Now, what? What do you do now? What is the process?
Okay. Likely, they're going to make that claim to an outside agency. And the outside agency is going to, in some cases, mail you a hard copy. In some cases, in some states, it would be an email. And it identifies what this person has charged. And then in that document, it will also let you know that what's required, whether it would be a position statement, which is really a report identifying what the process was and anything that the employee claimed. Sometimes the employees are super general in their claims, so it makes it hard to dive into detail. There's some assumption that's made, but that's all written in the position statement. And then that position statement also will cite a number of, we call them tabs. They're pieces of evidence, right? Maybe their offer letter would be one that shows that they were in employment. Their job description might be one of the documents. It depends on what the wrongful termination statement is, or if it's just, I was wrongfully terminated, period. That could be the claim. The employee gets to decide. And so then the termination letter would be a document. Perhaps there's corrective action that has been happening that identified that there was either a behavior or a performance issue, because those are two different things. So like if somebody's having a hard time getting to work on time, staying for the whole shift kind of thing, no call, no show, that's a behavior. When someone's having a hard time hitting their deadlines or following the protocols within the project, that's a performance issue. And so what kind of documentation is there? What conversations have happened? Was there retraining provided? Anything like that. And then also any policies within the handbook that were followed. For instance, if you have a handbook and you have the EEO statement, that statement saying that you make all employment decisions from hiring, everything that happens in the employment cycle to termination in a fair and just way without consideration of any protected class, right? You're inclusive and supportive. And so all those things would be evidence that would be used to provide to the agency, whether it's federal or state, that is handling the case. And then they review and make a determination. In some states, when there is no finding, no determination, then the employee is given a right to sue letter. So it's not necessarily over. And so it depends on the strength of the position statement and an attorney's review that the employee goes to. Generally, they're going to have legal representation to sue, whether they feel like there's need to, go forward.
Yeah. And I would assume, because I've seen that also on the corporate side, that doing the investigation, and if it ends up being a real dispute where the employer turned out that they did something wrong, it's probably a lot cheaper to go through mediation versus the actual lawsuit, correct?
Yes, when you're in that situation as the employer and you know your supervisor or you made a mistake, you did the wrong thing, then mediation is always the first step in that offering. Would you like to mediate? And then sometimes it works and sometimes it doesn't. And sometimes it's not necessarily monetary in the settlement, but often it is. And so the deal is it's really expensive to end up with a case where you have to do a position statement and prove everything you can that you didn't do something wrong, or that you have found there was this one piece that we did, we corrected it. And because employers are allowed to be human, but to then end up in court and litigation and lose, right? I mean, it's expensive. Even entering mediation can be expensive because you feel like it's a loss. But to win, to write that position statement, to have that written for you and get the no findings, that's still expensive too, because you've paid for the expertise to get that done. Now it's less expensive, but it's not free. And so the very best way is to have a few policies in place, have communication, strong communication, ongoing communication with your employees, create an environment where they feel safe coming to you. And when you don't know what to do, the first thing you say is, I can see this is important and we want to get this right for you. That is an HR employment mantra. We want to get this right for you. Let me look into this. You've done two things. You've given some value to the employee and you've given yourself some time to figure out what the heck to do. We've never had this. I don't even know what this means, right? And then get back to them. Let me get this right for you. I want to check on a few things. Let's reconvene after lunch, tomorrow morning, whatever it is, and then be sure you do. Even if it's to say, I have found some information. I need a bit more. So thank you for coming back together. I need to ask if we can meet after lunch today, right? Communicate. Keep the lines open, because in the absence of your communication, it's MSU, and that's making stuff up.
True. Yeah. So, I always like to make sure that Maine is very specific with small businesses. And, small businesses, the chances are you don't have an HR person on staff that can go and fix this for you. And thank you for giving us that wording, because, I'm kind of used to that from the corporate environment, the HR speak, so to speak. And some business owners might not have heard that. So this is very, very helpful, especially if you don't have an HR person on staff. But what happens if, your employee comes to you, you give them this, thank you for bringing this to me. I'm going to look into it. I want to make this right for you. What do you do then? Do you go and you hire an HR consultant, a fractional HR person? What is your next step, especially when you don't have the background in HR or the knowledge and the expertise to figure out, what do I do with this now? Like, what do I do with this?
Excellent. So get help is absolutely right, what you're saying. And, generally it's free to find an HR consultant that can talk to you just at the high level. Hey, I've got this situation going on. I don't have an HR person. What would we want to do, and what would that look like? How would we get help with that? And if you've contacted an HR person that doesn't do investigations, they likely know who could do that. So an HR consultant can do your investigation. You want to make sure they're certified so that they know what they're doing. You'd like to know if they've ever done an investigation before. And if that HR person starts talking about an attorney, that person is in the know, right? We want to be sure that the organization is completely covered. So if someone were to call us, we would be able to say, our experience and all of that. And we would say, we often will work alongside an attorney through the investigative process. And of course, this conversation with us is free, as it would be with any other HR consultant, I'm relatively certain. Just we're not giving advisement, but just giving process. And we would recommend we have someone, if you don't already have an employment law attorney, right? You want an employment law attorney or labor attorney. And having a conversation with them the first time is generally also free to understand, this falls in a realm where you're likely good to work with your HR consultant. Where here is something more unfold. Or you would hear, this is a good thing to have us in the background, so you're not paying the attorney fee for everything that's being done, but only when the attorney's expertise is needed. And so that's what you would be looking for. Small companies don't need to have an HR person. They need to have an HR resource so that they're kept abreast of all the new stuff that's coming through, and they can reach out and say, hey, someone just said they've been experiencing harassment. What do we do?
This is great information, Jill. So if someone is listening to this, they own a business, say, oh my goodness, I don't know what to make of this. It's making me really nervous. What should I do right now? Something that I can do to guard my business against someone bringing forth an accusation that they were wrongfully terminated, or maybe there's a hostile environment. What could they have so that if something like this happens in the future, that they feel more prepared and they know, what the next steps are? What can they do?
So a couple of things. One, they can get themselves educated. There's a lot of programs online where they can learn what to do next, how to support a culture shift, right? Because they already know they haven't really given attention to their culture, and culture will always develop. It's just a matter of whether it's done intentionally or not. And then
whether it's developed by you or not. Yep.
Yes. And culture is developed by the people you hire. So that's where it starts. No matter what your vision, mission, and values say, if you're not hiring people that are aligned with your vision, mission, and values, then your culture is not going to likely grab and embrace those that mission, vision, and values. So it starts at the hiring piece. But there's a ton of things out. There are podcasts, such as yours, which is, of course, the best, to help individuals become more knowledgeable. If I were in a position as an employer and I needed accounting, I wouldn't attend those seminars where I can learn accounting. I would reach out to an expert. That's the fastest way to help you. Reach out to an HR expert. And they are, are abundant. There are many in every state. There are many that work in multiple states. Get professional help so that you do it right. Because Google, we describe as a very expensive tool. Because unless you can put your question in to say, here's my situation, what do we do when? On an odd day of an even month when the sun is shining, because you need all those little caveats, right? And so then, we have AI now. We can put all that in there, right?
Yeah.
And what I will say is you might get some good information. We have played with it. You can get good information, but sprinkled within is inaccurate information. And it takes an expert to understand that, if it's not a big deal, you don't have to do anything. Okay, we would say, absolutely not. No, you never ignore. It's always handled. Sometimes it's just a mere conversation. sometimes it's listening and giving the employee a voice and sharing the appreciation that they brought this forward. So now you can keep a pulse on a situation, right? And so I would say get help from an expert. Consulting is present to make employers' lives easier so that you can focus on your business, how your bottom line, how you make money, and you can bring in your IT and your accounting, your HR, your, whatever else there might be in the way of need for the organization. Don't try to learn it all.
Yeah. And there's, these are complex topics and it requires, there's context and nuances in every single one of these things.
Yeah.
So thank you for that, Jill. Where can our listeners find you?
Whoa, thank you for that. Our company name is Southwestern HR Consulting. We can be found at our website that is swhrc.com.
All right. Perfect. And all of these are actually going to be in the show notes too. And you can find Jill's website there and her contact information. Thank you so much for this very insightful conversation, Jill.
Oh, thank you, Kathy. It's been a privilege.